Europe thought they had won. What was celebrated as the most aggressive economic sanction in modern history was framed as a decisive moral victory. The European Union seized $245 billion in Russian assets. Central bank reserves were taken, oligarch properties confiscated, corporate holdings nationalized. The move was supposed to cripple Russia, force political change, and prove that aggression carries consequences. In Brussels, champagne flowed. Politicians competed for credit. Media outlets praised unity, resolve, and courage. Then Russia's legal team filed a single document, 847 pages long, filed simultaneously in 14 jurisdictions across 3 continents. Within 72 hours, European legal experts were calling it the most sophisticated legal warfare operation they had ever seen. Within 2 weeks, governments were quietly panicking. Within a month, Europe's signature punishment against Russia was already unraveling. What followed was not military retaliation. It wasn't economic warfare in the traditional sense. It was something far more effective. Pure legal strategy, exploiting weaknesses in European law that almost no one anticipated. And it worked. This is the story of how Russia turned Europe's greatest weapon against itself, why European lawyers are now privately advising settlement, and what this means for the future of economic sanctions everywhere. To understand how this happened, you need to understand what Europe actually seized. When Russia invaded Ukraine in February 2022, Western governments froze roughly $300 billion in Russian central bank reserves. The European Union controlled the largest share, about $245 billion. For 2 years, those assets remained frozen. Russia demanded their return. Europe refused. Then in November 2024, European leaders crossed a line no major power had crossed before. They moved from freezing to confiscation. The assets were seized outright and transferred into a Ukraine reconstruction fund. The legal justification was improvised. European leaders declared the funds to be reparations for Russian aggression, citing principles loosely derived from post-World War II international law. It was legally fragile. Multiple legal advisors warned it violated international law, sovereign immunity doctrines, and even the EU's own treaties. Those warnings were ignored. Political urgency overwhelmed legal caution. The seizure went forward. Russia's initial response appeared restrained. Strong statements, promises of consequences, diplomatic protests. European leaders interpreted the silence as weakness. They assumed Russia had no meaningful response. That assumption was a fatal mistake. Russia had been preparing for this exact moment for 2 years, not hoping it wouldn't happen, but planning for when it would. They assembled an international legal team composed not of Russian lawyers, but elite firms and experts from Britain, France, Switzerland, and the United States. These lawyers spent 2 years dissecting the asset freeze, studying precedent, identifying vulnerabilities, and preparing arguments. They discovered what European lawmakers missed in their rush to act. The legal mechanism Europe used depended on classifying Russian assets as ordinary state property subject to enforcement. But international law draws a sharp distinction. Central bank reserves used for monetary policy are protected by absolute sovereign immunity. This protection is recognized under customary international law and codified in treaties like the UN Convention on Jurisdictional Immunities of States and Their Property. European courts had upheld this principle repeatedly. That's why Europe froze the assets, but hesitated to seize them for 2 years. The confiscation crossed a legal red line. To justify it, Europe reframed the seizure as reparations rather than enforcement. Russia's legal team identified this as the weak point and exploited it with precision. Their filing argued 4 core points. First, the seizure violated sovereign immunity. Central bank reserves are not ordinary assets and cannot be confiscated unilaterally. Second, the reparations argument was legally invalid. Reparations require a peace treaty, an international tribunal ruling, or voluntary agreement. None existed. Third, the seizure violated the EU's own legal framework, which protects property rights and requires due process. Russia argued EU law was being applied selectively, undermining its own foundational principles. Fourth, and most strategically, Russia argued the seizure endangered global financial stability. If sovereign reserves can be taken by political decision, No country's reserves are safe. This incentivizes capital flight from Western systems and undermines global finance. Russia positioned itself not as a violator, but as a defender of the international financial order. The filing included something extraordinary: evidence that EU member states themselves had disagreed internally about the legality of the seizure. Internal warnings, legal objections, and political overrides were documented. How Russia obtained internal European communications was never explained, but the implication alone caused panic. European governments couldn't determine whether the leak came from hacking, insiders, or intelligence penetration. The uncertainty was destabilizing. Russia compounded the pressure with jurisdictional strategy. They didn't file in one court. They filed in 14 simultaneously: the International Court of Justice, the European Court of Human Rights, the Permanent Court of Arbitration, commercial courts in London, Switzerland, Singapore, investment treaty tribunals, and even US federal courts. Europe now had to defend itself in 14 separate legal arenas. Each case required different teams, arguments, and timelines. The cost alone was immense. Worse was the risk of inconsistent judgments. Russia only needed to win once. Europe needed to win everywhere. Within weeks, cracks appeared. A Swiss court issued a preliminary injunction blocking European use of certain seized assets. The money remained frozen but unusable. Arbitration tribunals issued similar orders. The European Court of Human Rights agreed to hear the case on an expedited basis. None were final rulings, but they signaled real legal risk. Investment treaty claims proved especially damaging. Russia argued that bilateral investment treaties protected its financial assets from expropriation. Europe countered that central bank reserves were not investments. Russia responded by citing Europe's own past legal arguments, defining sovereign financial assets as protected investments. Under international law, states cannot contradict their own established positions. Courts take estoppel seriously. Europe was trapped by its own precedent. Financial markets reacted quietly but decisively. Capital began moving out of European institutions, not in panic, but steadily. Bond yields rose, the euro weakened, borrowing costs increased, insurance premiums surged, banks reduced exposure, political divisions deepened, Eastern EU members faced backlash, Western members distanced themselves. Unity fractured. Some quietly proposed settlement, others demanded resistance. The debate turned public and bitter. Russia's strategy was never about immediate recovery of all assets. It was about creating legal paralysis. As long as the money remained frozen in limbo, Europe couldn't use it. Legal costs mounted. Political will eroded. Time favored Russia. These cases will take years. By then, public urgency will fade. The greatest risk for Europe is reputational. A ruling against the seizure would confirm Europe violated international law, undermining its moral authority. Russia's brilliance was using Europe's own legal system against it. Independent courts, rule of law, judicial integrity. Europe's strengths became liabilities. Russia likely won't recover every dollar, but it will recover enough to redefine the narrative. Europe sought to prove power. Russia proved limits. Sanctions are no longer permanent. They are challengeable. The deterrent effect weakens. A blueprint now exists. This is modern power competition. Not tanks and missiles, but filings and forums. Europe seized $245 billion in a moment of political fury. Russia is dismantling that seizure with patience, law, and strategy. And Europe cannot stop it without abandoning the principles it claims to defend. What makes this second phase even more dangerous is that the legal fight has quietly evolved into something much larger than a dispute over money. It has become a stress test of whether the Western financial system can still claim neutrality. Every court filing, every injunction, every procedural delay reinforces the same idea in the minds of global decision makers that assets held inside Europe are no longer protected by law alone, but by politics, and politics can change overnight. Central banks are not waiting for final rulings. They are adjusting now. Reserves are being rebalanced, custodial relationships quietly reviewed, exposure to European clearing systems reduced in ways that never make headlines, but absolutely change flows. This is how confidence erodes, not with panic, but with spreadsheets. The irony is that Europe still technically controls the money, yet functionally cannot use it. Ukraine cannot rely on it, markets cannot price it, and governments cannot leverage it without risking further legal backlash. The funds exist in a kind of financial purgatory, frozen not by sanctions anymore, but by law itself. That outcome alone represents a strategic loss. Meanwhile, Russia absorbs the pressure far more comfortably than Europe expected. Its economy adjusted, trade routes shifted, alternative payment mechanisms expanded, and domestic political cohesion hardened rather than cracked. Time, which Europe assumed was its ally, is now Russia's greatest weapon. Each year these cases drag on, the political urgency fades, public attention moves elsewhere, and the appetite for endless legal spending declines. Future European governments will inherit this problem without the emotional momentum that justified it in the first place. That is where Russia's patience pays off. This also reshapes how future sanctions will be perceived. The psychological shock of freezing reserves once relied on the assumption of permanence. Now that assumption is gone. If sanctions can be challenged, delayed, partially reversed, or tied up for years, they lose their deterrent power. Countries watching this unfold are learning that compliance is not the only option. Resistance through law is viable. The lesson being absorbed globally is simple. If you prepare early, build legal alliances, and exploit institutional contradictions, you can survive sanctions long enough to outlast the political will behind them. Europe now faces an impossible dilemma. If it compromises, it admits legal weakness. If it fights, it risks precedent that permanently limits its power. Either path erodes authority. The system Europe helped build was designed around predictability, trust, and rules applied consistently. By breaking those rules for short-term political gain, it exposed the system's most fragile point. Power that depends on trust cannot survive selective enforcement. This is no longer about Russia winning back money. It is about rewriting how financial power works in a multipolar world. The shift is subtle, legalistic, and deeply consequential. And by the time the final judgments arrive, the most important change will already have happened. The world will have learned that the Western financial system is not unchallengeable. It can be fought, stalled, and reshaped using its own laws. That realization will outlive this case, outlast this conflict, and redefine economic warfare for decades to come. The most underestimated consequence of this legal war is what it does to behavior long before any verdict is reached. Markets do not wait for final judgments. Institutions do not wait for clarity. They react to uncertainty itself. Once uncertainty becomes structural, it changes how money moves. European custodial banks are already seeing quieter but persistent shifts as clients ask for redundancy, secondary jurisdictions, exit options. Compliance departments expand, legal reviews multiply, transaction timelines stretch. None of this looks like crisis on the surface, but together, it drains efficiency from the system. Financial power is not just about control, it is about speed and reliability, and Europe is losing both. At the same time, countries outside the Western Alliance are learning an uncomfortable but empowering lesson. The rules are not fixed. They are negotiable if you are willing to contest them aggressively enough. Russia has demonstrated that even when outmatched economically, you can force stalemate through law. That lesson will not be forgotten. It will be studied, refined, and reused. The next time sanctions are imposed, targets will already have legal playbooks prepared. They will pre-position assets, restructure holdings, and draft filings before the first announcement is even made. The element of surprise, once central to sanctions effectiveness, is disappearing. Europe now has to confront a reality it has avoided for decades. Its influence was never just economic size, it was trust in its legal environment. When that trust weakens, influence follows. This is why the damage extends far beyond this case. Every future negotiation, every trade agreement, every diplomatic demand now carries an unspoken question. Will Europe follow its own rules if the politics become inconvenient? That question alone weakens leverage. The most revealing aspect is that none of this required escalation, force, or retaliation. It required patience, preparation, and faith that institutions would behave as designed. Russia did not attack the system from the outside. It stepped inside and pulled on the threads Europe itself had woven. That is why this episode will be remembered not as a failure of sanctions enforcement, but as a turning point in how global power is contested. Economic warfare is no longer about freezing accounts. It is about contesting legitimacy. And once legitimacy is questioned, power becomes conditional. Europe still holds money, Russia still waits. But the system both relied on is already changing, quietly, legally, and irreversibly.